Welcome back to Death Row Cases. Last time we told you the first part of Dennis Sochor's case, the disappearance of 18-year-old Patricia Gifford on New Year's Eve, 1981, and how Sochor managed to stay out of the hands of the law for 5 years. This time, the arrest, 3 confessions, and a trial that came down to one stubborn question. Who was lying, Dennis or his own brother Gary? And as you'll hear by the end of this episode, this is one of those rare cases that eventually made it all the way to the U.S. Supreme Court before the conviction had even become final. For anyone joining for the first time, on New Year's Eve 1981, Dennis Sochor and his brother Gary met 18-year-old Patricia Gifford at a bar in Broward County, Florida. Later that night, Patricia left with the brothers in Sochor's work van. She was never seen alive again. Her body still hasn't been found to this day. Sochor fled after his photo aired on local television. 5 years after Patricia Gifford's disappearance, Dennis Sochor was arrested, not for the murder, but for running a red light in DeKalb County, Georgia. A routine traffic stop that turned into something much bigger. Before we get into what happened during those interrogations, it's worth pausing on what an interrogation actually looked like in the mid-1980s. Miranda rights, the right to remain silent and the right to an attorney, had existed in the American legal system for about 20 years at that point, since the 1966 ruling in Miranda versus Arizona. Even so, practices varied a lot between police departments back then, and interrogation techniques were generally more direct and less regulated than they are today. Recording equipment existed, but video-recorded interrogations, the kind that capture the entire session on camera, weren't yet standard practice. That matters because it shapes how judges and jurors at the time, and defense attorneys decades later, look back on the validity of confessions like these. Once in custody, Sochor gave not one, but 3 separate recorded confessions. That's notable and worth pausing on. Most suspects in a murder case don't confess multiple times separately. For prosecutors, that's actually strong evidence. A single confession can later be challenged, retracted, or dismissed as the result of pressure during questioning. 3 separate recorded confessions are far harder to refute. They leave much less room for a defense to argue there was a one-time lapse, a moment of confusion, or improper pressure from the interrogating officers. One key detail from those interrogations. Sochor stated that his brother Gary wasn't present at the exact moment of the murder. That becomes the pivot point of the entire trial. While Dennis had to stand trial, his brother Gary took on a different role, that of star witness. According to the defense at trial, the prosecution's entire case came down to the question of which of the 2 brothers was telling the truth. The closing arguments put it bluntly. Only 2 people actually knew what happened, and that was Gary and Dennis Sochor themselves. According to the prosecution, Dennis lied to save himself. According to the defense, it was Gary who lied to cover up his own role in the night of the murder. This kind of situation, where close family members end up facing off in court, one as the defendant and the other as the star witness, comes up in American criminal law more often than you might expect. Family members know each other best, are often present at the moment itself, and at the same time have the strongest incentive to protect either themselves or each other. For a jury, that's an especially difficult position. How do you weigh the testimony of someone who has both the most knowledge of the case and the most at stake in a particular outcome? What the jury either didn't fully hear at the time or what only surfaced much later. Gary Sochor had reportedly been granted immunity from prosecution in exchange for his testimony. Sochor's attorneys would argue decades later that this fact, crucial to assessing Gary's credibility as a witness, wasn't disclosed to him until one day before he testified, and that the prosecution never fully revealed it to the defense. That's exactly the kind of disclosure American law has a name for, the Brady Doctrine, named after the 1963 case Brady versus Maryland. That ruling obligates prosecutors to share exculpatory evidence that could work in the defendant's favor with the defense. If a prosecutor knows a star witness has been granted immunity, that's exactly the kind of information a jury needs in order to properly weigh that witness's credibility. After all, someone with nothing left to lose by testifying has a very different incentive to say something than someone who could still be prosecuted themselves. We'll come back to this in more detail in the next episode, because it became the foundation of a legal fight that would stretch on for years, right up to our own time. There's another aspect of these trials worth mentioning, because a lot of people, including plenty of Americans, aren't fully aware of it. In American death penalty cases, juries are put together in a very specific way. Before a jury is sworn in, potential jurors are asked whether they'd be able and willing to impose the death penalty if the law and the facts called for it. People who are categorically opposed to the death penalty and would therefore never be able to vote for such a verdict are typically excluded from serving on these juries. This is known as a death-qualified jury. Supporters of this system say it's necessary to make sure a jury can actually apply the law as written. Critics point out that this selection process tends to tilt the jury, on average, slightly more toward conviction and the death penalty, simply because part of the population is excluded from participating in the first place. It's one of the many ways the American jury system in death penalty cases differs from ordinary criminal trials, and from how many other legal systems around the world handle questions of guilt and punishment, often through professional judges rather than a jury of citizens. For anyone unfamiliar with the American legal system, it's worth taking a step back here. A death penalty case in the United States typically moves through several layers. First, there's the trial court, where the actual trial takes place, in this case in Broward County. From there, a convicted person can appeal to the state's highest court, in Florida's case, the Florida Supreme Court. If that doesn't succeed either, a case can, in certain circumstances, go to the U.S. Supreme Court, but only if there's an issue involving the federal Constitution, as there was here. And even after that entire process, a case isn't necessarily closed, because what often follows is a separate track of appeals known as the post-conviction phase, where the original conviction itself isn't being challenged, but rather whether new information has emerged that wasn't known at the time. That's exactly the track Dennis Sochor would end up on after 1993. And it's what Part 3 of this series focuses on. One more term we already mentioned briefly, and that's worth quickly explaining: aggravating and mitigating circumstances. In most American states with the death penalty, including Florida, a judge has to weigh things on a kind of scale when determining a death sentence. On one side are the aggravating circumstances, factors that increase the severity of the crime, like cruelty, premeditation, or the fact that a victim was kidnapped before the murder took place. On the other side are the mitigating circumstances, factors that could justify some degree of understanding or leniency, like a difficult childhood, mental illness, or a lack of prior criminal record. In theory, a judge is supposed to weigh these two sides against each other before imposing the harshest sentence. On November 2nd, 1987, Dennis Sochor was convicted on charges of both kidnapping and premeditated murder. Those two charges together are typical of how American prosecutors build cases like this. The kidnapping charge underscores that the victim was taken against her will to the place where the murder happened, which in turn can count as an aggravating circumstance when determining the sentence. The jury recommended the death penalty by a vote of 10-2. Two jurors, in other words, believed a life sentence was more appropriate. In Dennis Sochor's case, the court found 4 aggravating circumstances, and not a single mitigating one. That last part is notable, and it's something we'll come back to in Part 3 of this series, because years later, Sochor's attorneys would argue that there actually were mitigating circumstances that hadn't been adequately presented at trial. For now, it's enough to note that the court at the time saw no reason to temper the severity of the sentence. Here's a detail few people outside America will know. In most death penalty states, a unanimous jury recommendation is required before a judge can sentence someone to death. Florida is one of only 2 states where a non-unanimous recommendation can still result in a death sentence. In other words, if this case had played out in almost any other death penalty state, Dennis Sochor almost certainly wouldn't be on death row today. This detail about the non-unanimous jury is more complicated than it first appears, and it's worth pausing on, even though it means jumping ahead to events that wouldn't play out until decades later. At the time of Dennis Sochor's 1987 trial, Florida actually had a rule that was even more lenient than the 10-2 ratio his case ultimately reached. Back then, a simple majority of the jury, 7-5, was enough to recommend the death penalty. In 2016, this system looked like it was about to change dramatically. The U.S. Supreme Court ruled in Hurst versus Florida that the system in place at the time, where a judge, rather than the jury, ultimately determined the decisive facts, violated the constitutional right to a jury trial. The Florida Supreme Court applied that ruling later that year and held that a unanimous jury recommendation would now be required for a death sentence. The Florida legislature formally wrote that into law in 2017. For a number of death row inmates, this opened up a new opportunity. Roughly 150 people who had previously been sentenced based on a non-unanimous recommendation became entitled to a new sentencing hearing. But not everyone. This rule only applied to inmates whose convictions had become final after June 2002, the date of another major ruling called Ring v. Arizona. Sochor's conviction, as we discussed earlier this episode, had already become final back in 1993, well before that cutoff. As a result, his case fell just outside the group that could claim a new sentencing hearing, even though his original 10-2 recommendation was exactly the kind of verdict the Supreme Court had found problematic. The story doesn't end there, by the way. In 2020, the Florida Supreme Court itself, following a change in the composition of its judges, reversed its own position and ruled that a unanimous recommendation wasn't constitutionally required after all. And in 2023, the Florida legislature went a step further. Following a high-profile case in which a school shooter received a life sentence because the jury didn't vote unanimously for death, the law was changed so that 8 out of 12 jurors are now enough again to justify a death sentence. With that, Florida, along with Alabama, once again has one of the lowest thresholds in the country for imposing the death penalty. In other words, the jury recommendation in Dennis Sochor's 1987 case would, under Florida's current law, still be perfectly valid today. But even during the years when a unanimous recommendation was required, Sochor never benefited from that, simply because his case had become final too long before. It's one of those quiet, technical details that can mean the difference between life and death, and that almost never make headlines. The judge upheld the recommendation. Sochor was sentenced to death. And then something happens that you don't see in every death row case. The case goes to the Florida Supreme Court on appeal, which upholds both the conviction and the sentence. But it doesn't stop there. Sochor's defense then brings the case before the U.S. Supreme Court itself, the highest court in the country, the body that ultimately determines how the American Constitution is interpreted across all 50 states. The Supreme Court sends the case back to Florida with a specific instruction. Conduct what's called a harmless error analysis regarding one of the aggravating circumstances the trial court had found. In plain terms, this means the Supreme Court had doubts about whether one specific part of the sentencing rationale had been legally applied correctly, and wanted Florida to reassess whether that error, if it existed at all, had actually affected the final outcome. A harmless error test is a standard way, in American law, of distinguishing between mistakes so minor they couldn't have changed the outcome, and mistakes so fundamental that the entire conviction needs to be reviewed again. It's a fairly technical point, but it underscores something important about this whole case. Even when it comes to precise legal details like this, details that might seem trivial to an outsider, death penalty cases are fought down to the bone. There's simply no room for carelessness when the outcome is irreversible. Every aggravating circumstance a judge weighs when determining a death sentence has to be legally airtight, because if even one part of that calculation turns out to be wrong, it can, in theory, undermine the entire sentence. Florida carried out the requested analysis and once again upheld the conviction and the sentence. That made Sochor's conviction final in 1993. By that point, his case had already been underway for 7 years, from the confession in 1986 to the final confirmation in 1993, and that was only the beginning of what followed. From here on, a completely different kind of legal fight begins, no longer about whether the verdict was reached correctly, but about whether new information has surfaced since then that changes the whole picture. And that's exactly what we're diving into in the final part, releasing later today. This legal journey from confession in 1986 to conviction in 1987 to a stop at the country's highest court to a final ruling in 1993 shows just how long and layered the American legal system can be in death penalty cases. And as you'll hear later today, this was, by a wide margin, not the last chapter. Next, in the final part of this series, how Dennis Sochor spent nearly 40 years on death row, the legal fight over his brother Gary's immunity that stretched well into the 21st century, his status as an American veteran, and the gripping final weeks before his scheduled execution, including his unusual legal argument about the method Florida uses to carry out the death penalty.